Hi, everyone. As Jackie mentioned, I'm Jameson Dempsey. I'm an associate at Kelley Drye and Warren, also one of the founders of DC Legal Hackers. Happy to talk about that later. But here, we're here today to talk about a particular type of relationship that's been coming to the fore as carriers try to differentiate their service offerings in the market. Specifically, we're here to talk about CarrierApp Partnerships and some of the potential opportunities, as well as some of the risks and ways to mitigate those risks. I feel like I'm in the unfortunate position of being the lawyer presentation. I know people tend to shut down during those. I also know it's lunchtime, but I think there's a real challenge out there where law and policy are kind of brought in like structural engineers getting brought in after the building is built. And so hopefully I'd like to present some best practices to everyone that you can use as you engage in these carrier app partnerships to mitigate some of the regulatory risks that you may face. So I'm going to talk about three things today. I'm going to talk about the current business landscape of carrier app relationships. Also talk about various legal and regulatory considerations, things that have been happening at the FCC that are relevant to these relationships. And then finally, I'm going to close it with some best practices. So the current landscape, as many of you know, carriers have been fighting for a long time to not be considered dumb pipes, to find ways to differentiate their service offerings in the market. It's very, very competitive within the mobile ecosystem right now, and that results in some really interesting business models and some really interesting partnerships. There are a few examples out there that everyone hears on the tip of their tongue, both in Silicon Valley and in Washington, D.C. Things like zero-rated applications and services, sponsored data, where a brand or an application will sponsor a user's data in order to offer free general purpose data or free access to certain applications and services. There are also pre-installed applications. In many circumstances, this is a carrier doing it on their own, pre-installing applications they think will be compelling to their consumers. But there are also pre-installed applications that come with a relationship, where the carrier has reached out to the application or the application to the carrier. They've struck some sort of deal to get in front of those eyeballs on the phone, and then to either share revenue or share based on, make money based on number of downloads, things like that. There are also a number of advertising-based services. I'm sure you're all familiar with companies like SlideJoy that offer lock screen advertising. This is another way where carriers and applications can come together. But each of these relationships bring with them particular regulatory and legal considerations. Now, there are many, many considerations out there, and I know we're just before nap time, but I don't want to put everyone to sleep, so I'm just going to focus on two of them. The first one is privacy and security. The second one is the open internet or net neutrality. So let's start with privacy and security. The current legal and regulatory framework, I know we have some companies here from the EU. The EU framework is markedly different from the way we approach it in the US. The EU has one omnibus law that applies across the board. It was just enacted, just changed. In the US, we have sector-specific and data-specific privacy and data security laws and rules. So, for example, sensitive data is treated to a higher level of privacy obligations, for privacy protections than non-sensitive information. So you can think of children's information that's covered by a law called CAPA. You have healthcare information that's covered by a law called HIPAA. And then you have financial information. That's covered by another law called the Gramm-Leach-Bliley Act. These are three politicians who named the law after themselves. But that deals with financial information. It's known colloquially as the GLBA, or GLBA. There are also general purpose laws. The FTC, Federal Trade Commission, has something called Section 5, and that deals with unfair and deceptive trade practices. That's, for example, times where a privacy policy says one thing, but the company's practices reveal something different, or where a company fails to have adequate data security protections. These are unfair practices. It's unfair to consumers not to have reasonable security in place. But here, today, we're really focusing on the way that the FCC, the Federal Communications Commission, approaches privacy and security. There are two specific laws at issue here. One's called Section 201B, one's called Section 222. Section 201B, this is the general purpose law. This deals with unfair, unjust and unreasonable practices. Once again, not having adequate privacy in place, adequate security in place. And then also, once again, these deceptive sorts of trade practices, saying one thing but then doing another. Section 222 is the other, and this is the FCC's real big hook historically into privacy. Section 222 deals with something called customer proprietary network information. Now, that's also known as CPNI, and what that is essentially information about a user's use of the network. So in the old telephone context, it's the phone calls that you make. It's your call detail records. It's your billing information, what services you subscribe to. And to the extent that that information is individually identifiable, it's covered by Section 222. Now, a year ago, the FCC expanded that, and I'll talk about the net neutrality considerations in a little bit, but expanded that to cover broadband information as well, and additionally expanded it to cover not just CPNI, so this limited subset, but also all proprietary information. That's all personal information about the consumer. So the FCC has taken this very broad interpretation of its own authority with real implications, not only for the carriers themselves and the way that they behave, but also for the applications with which they partner. Before we move on, states also have their own privacy laws, and then there's also a lot of industry self-regulation in the privacy space. CTIA has their own code of conduct that deals with some of these issues. How are these laws enforced? They're either enforced by the agency or they may be enforced by what are called private rights of action. So those are consumers bringing complaints against the companies either in court or at one of these regulatory agencies. Now, if you're an application provider and you're partnering with a carrier, there are a number of considerations that are extremely important that you guys should keep top of mind. The first is to do an inventory. What data is my application collecting about consumers? Is it their personal information? Do I have financial information? Right? We talked about some of the sensitive information. Do I have that? Am I storing it? Once I'm storing it, how am I using it? Am I using it for purposes that are adequately disclosed within a privacy policy? Am I sharing it with third parties? Am I trying to make money off of it? And if I am sharing it, how am I sharing it? Am I sharing it in a de-identified way, or am I sharing it with full identification? Different privacy considerations come up in these contexts. How am I protecting the information? Also huge. Am I storing it on a cloud server somewhere? Am I storing it locally on my own server? Am I storing it with a third party? Do I have a relationship with this third party to ensure that there's pass-through of these protections? And if I'm, for example, white labeling a product and sending data back to the carrier, how's the carrier using that information? Now, this is actually really, really important. So in the way that the federal government works, applications generally are covered by the FTC's Section 5 that I just talked about. Carriers are covered by the FCC's Section 222, Section 201. But as a carrier dealing with as an application dealing with a carrier, I might be covered in some sense by either, or have risks that are faced by this because of this relationship. And so what you want to do is you want to look at the contracts that you have with the carrier. What protections are embedded within that contract? Who's responsible in the event of a breach? What are the steps that I need to take? Who's going to disclose these privacy practices? Is it my obligation as the application provider, or as a white-labeled product, is this something that the carrier is responsible for? So these are the sorts of things that you want to consider from a privacy and data security context as you are developing these partnerships. So what can you do for privacy and data security? I've boiled it down to 4 things. Number 1 is due diligence. Perform an inventory, figure out what the carrier wants to do with the application's information, personal information collected by the application. Number 2, contracting, as I just mentioned. Actually read the contract. You wouldn't believe how many times a contract gets dropped on our desks, and we look at it, and privacy and security was an afterthought, if it was thought of at all. Maybe it was copy and pasted from another agreement, but was never read. Well, in the event of a breach, in the event that something comes wrong, the agencies are going to want to look at those contracts. They want to understand what the relationship was all about. And unless you've addressed these issues, there are huge risks that come with that. To the extent that you have staff and they're dealing with personal information, do you have training in place? And how are you monitoring the way that information is collected? How are you monitoring third parties that you're using, for example, cloud storage? And so these are some of the key considerations that everyone should address from the applications perspective as you're engaging in these relationships with carriers. Now, the second issue that I want to talk about is the open internet. So the relationship between common carriers, telecom providers, and companies that are providing data services, or data services in general, has been raging now for well over 50 years. But it's really in the last 15 years that we've had this concept of the open internet, of net neutrality. The FCC in various forums has tried to pass open internet net neutrality regulations, and up until last year, they've been knocked down every time. But last year, something different happened. Last year, the FCC decided to reclassify broadband services as common carriers. And the court, the DC Circuit, that was looking into this, ruled that the FCC did this in a permissible way. And so as a result, the open internet rules that the FCC enacted last year are in place, they are enforced. The FCC is looking now at some of these specific relationships between carriers and applications, and the way that it affects consumers' interaction with the internet. So let's talk quickly about the 2015 Open Internet Order. It sets forth 3 bright line rules, and then a general conduct standard that's kind of a broad standard that we'll address that deal with some of these specific relationships between carriers and applications. So what are the 3 bright line rules? We have no blocking. You can't block as a carrier. You can't block certain applications, services, or devices unless there's a technical, reasonable network management reason to do so. As a carrier, you also need to be transparent about your practices. Disclose any network management practices. Disclose the speed of your broadband services. Disclose third-party relationships that you have. And then there's this general conduct standard. And the general conduct standard says essentially that you can't unreasonably disadvantage certain applications, services, devices on the network. And it's left open. Why did the FCC do this? Well, for the last 15 years, it's known about no blocking, no throttling of certain traffic, no paid prioritization. But the general conduct standard addresses some of these business relationships that carriers are starting to embark upon. The general conduct standard is intended to deal with things like zero rating of applications. It's supposed to deal with sponsored data. Now, the FCC is in a quandary because some of these zero rating and sponsored data business models seem to be pro-consumer. Get all the video that you want. Right? Get free access to Facebook or free access to Wikipedia. But the public interest community says, well, the short-term effects may be good for consumers, but the long-term effects may be harmful. So the FCC said, well, we want to do this on a case-by-case basis. It's still very new, but this is something that we want to look into. And John Wilkins from the FCC just yesterday reiterated that they're looking into this on a case-by-case basis. And so really we're just waiting for the shoe to drop. We're looking for that test case. The FCC did it in privacy. They released a test case that kind of set the parameters for the rest of the industry. We're expecting something similar on the open internet front. So what are some of the key questions that you should ask as an application provider when you are engaging in carrier relationships? Well, first of all, what are you asking for in the relationship? What's the benefit of the bargain with the carrier? If you're asking for an exclusive deal to the exclusion of other applications, that may raise open internet considerations. If you are asking to be faster than other services, that could raise open internet considerations, the throttling rule, if you're faster, or paid prioritization rule, if you're asking for faster access to the consumer. But you may also want to look at the specific business model that you have in place. If the business model deals with sponsored data, if I'm an application and I say, listen, I'm going to pay $5 a month for each consumer, something like this, in order to get on the screen, and you can use that data, or you can use that money to put it toward data in excess of the data cap for that application. Then we're in sponsored data territory. You may ask for 0 rating as well of your application or of a certain class of applications, or for exclusivity for a certain period of time for your applications. Now, these are all big unknowns at the FCC. We haven't seen the test case yet. But if your business model is relying on some of these things, if you have contracts in place that assume some of these things, there may be particular risks. And so there are specific things that you can do as an application provider, as a carrier, to address these. Number one is be familiar with the rules. Take a look at what the FCC has said about sponsored data, 0 rating. To the extent you can pay attention to the trade press, either through a trade association or getting a subscription to one of these things. Certain sites like Recode and The Verge tend to follow these issues in depth. You can get a sense of what the FCC is thinking about. You can read the tea leaves, but you want to pay attention to those test cases because those may have an impact on current arrangements that you have or future arrangements based on the products that you are trying to develop. You may also want to address these things in the carrier's open internet statement. If you're engaging in these carrier partnerships, one thing that you may want to do is ask the carrier to address these particular application services or uses within their open internet transparency statement. And by doing that, you save yourself. And the reason that you do is, even though the FCC is very likely to go after the carrier rather than you as the application provider, the reputational damage that bad press from a transparency statement snafu or a privacy policy snafu could really impact your business. Now, the test case for this was CarrierIQ. CarrierIQ is a diagnostic program that was pre-installed on HTC phones. It was determined that they were collecting much more information about consumers that they said that they were going to. Consumers weren't aware of the diagnostic application, and there were vulnerabilities in terms of data security that caused real risks on these phones. Congress, the FTC, and the FCC got wind of it. They went after HTC, the OEM. They went after some of the carriers and investigated them. And the result was that the application provider, the diagnostic provider, ended up going out of business. However, with some due diligence, with some protection of data security, and with more disclosure of these practices, they could have avoided some of these problems. And so these are best practices that you, as an application provider, should be addressing. So I want to leave some time for questions, but before I do, I'd like to highlight a few best practices, really focused on privacy and data security, because we're still waiting on the open internet rules for the big test case. So best practices on privacy and data security. Number one, perform an inventory. How are you collecting information? Where is it going? How are you sharing it? How are you disclosing what you're doing to consumers? And how well are you living up to those promises? Number two, when you're engaging in partnerships, perform that due diligence up front. Figure out what the carrier wants to do with that information. Look into the potential risks and then take steps to mitigate that risk through your contracts. Number three, once again, training staff. You want to make sure that that your staff understands privacy and data security. Now, some would say that you need to have a dedicated privacy or data security person on staff. For small companies, if you're two guys, two gals in a garage, that may be too much, but at least being aware of privacy and data security laws, rules, and policies, I think would be beneficial. Make sure that you address privacy, security, and open internet considerations within your contracts with the carriers. And make sure that you're periodically, as you're monitoring what you're doing, as you're monitoring what third parties are doing that deal with consumer information, that you review and update the privacy policies as necessary. I will leave you with two pieces of wisdom that I got from the leader of our practice group, my boss, John, who's right here. Number one, don't be creepy. If what you're doing share it with your significant other, share it with your friend, and say, if your carrier were to do this or an application were to do this, would you be creeped out by it? If they say yes, trust your gut on that. You may want to take a step back or at least look for ways to mitigate the risk. And then finally, say what you do, be transparent about what you're doing, and then do what you say. Follow through with your promises. Because most of the enforcement that we see out there deals with situations where someone either doesn't disclose what they were doing or disclosed something that that didn't mirror what they were actually doing in practice. So with that, I'd open it up. We have about a minute for questions. All right. I guess that's it. Well, thank you all very much. Really appreciate it.